Okay, we're unmuted.
Okay, it is 4:15 on the 15th of April. We are now opening up the public comment meeting that we had previously scheduled to start 30 minutes after adjournment. We're like at 31 minutes, so I think we're right on track with that. The purpose of this meeting is solely to take public comments in response to the proposed regulations that were submitted through the state register in February of 2021 and in compliance with our requirements to have public hearing on those if requested. We have received, as requested, that we ask that people consider doing some written comment from Ralph Courtney and also from Disability Rights of South Carolina, but we did have 3 individuals who requested to speak publicly, so we'll be calling them in just a moment. Those 3 people will be limited to 5 minutes. This will be a strict limit of 5 minutes. It is solely for purposes of them to provide information to the commission on the proposed regulations. No other topics will be allowed. And no questions can be asked of the commission members. A commission member may request to be able to ask questions of those who are giving us their positions, if they desire. Anybody have any questions for me about that? That's what the plan is. Everybody in agreement with that, first of all? Okay, anybody got any questions for me? All right, so the first one who is requested to testify is Patricia Harrison, and Kimberly will be calling her now.
Do we know which policy she is
No.
calling in regards to?
She simply said she requested to speak, so we don't know with regard to which regulation.
Okay.
She may speak to one, she may speak to all.
Okay.
Patricia Harrison.
Ms. Harrison, this is Gary Lamel with the commission.
Hello, Gary.
We are prepared to begin, we're prepared to begin the public comment section with regard to the regulations. I don't know if you've been tuned in to see my prequel statements, but just by way of advisement, we have set a 5-minute limit with regard to this, and of course you may supplement with written testimony if you wish to after the fact. So with that understanding, I will recognize you for 5 minutes.
Is this being, I don't see it, I didn't see your opening statement. I've got are you broadcasting or is it muted?
It should, we turned on the microphone. It should be.
Okay, but it's because it's not coming through on my computer.
Hold a minute.
So I don't know if other people out there are able to hear.
Thank you, Patricia. We'll check on that. We won't count this against your time while we're figuring out our technical difficulties. Thank you for bringing that to our attention.
Okay, so are you sure it's live? Because you may need to reread your statement. I didn't hear it.
Okay. Other people have heard it. It's coming through, Patricia.
Okay.
I think it's just you. I just did an introductory statement just stating the purpose of this and explaining the process. Okay?
Okay.
So at this time, I will recognize you for your 5 minutes.
I am speaking as a family member and an attorney who has represented families with disabilities for over 30 years. My biggest concern is that after 10 years of litigation with P&A, the proposed regulations don't even make a dent in the directives and standards which establish binding norms that should be promulgated as regulations. I have a specific problem with the eligibility criteria using future DSM criteria because we don't know what that private entity is going to do. It could cause, if they change their criteria, it could cause thousands of people to lose their eligibility. I also have a concern that the regulations do not, the proposed regulations do not comport with the current version of DSM, which has removed a specific IQ score from the criteria. So it looks like it's used part of the old criteria and part of the new. One of my biggest concerns is that the regulations don't address compliance with the ADA and the requirement of the final rule that require placement to be in the least restrictive setting. I still have clients that are not being allowed choice of what setting they choose to live in. The regulation should provide that the rates paid to caregivers at home should be consistent with what's paid in the facilities. For example, the General Assembly gave $1 a year raise 3 years in a row, and that was not passed on to the providers who live at home. So they're having a terrible time now locating caregivers. Mr. Malley spoke about the difficulties in finding nursing. The nursing rates paid to people who live at home have not been increased at all. So the regulations need to address the inequities between people who live at home and the rates paid in the facilities. The regulations need to address consent, because I'm still seeing people with an IQ in the 30s providing consent to medical care, and parents don't even know when they're taken to the hospital. The TheraP module that was purchased without approval of the commission would allow parents or family members to log on and see what's going on with their family. And that needs to be addressed in the regulations and required that families be able to have access to that. DDSN is still allocating hours with no standardized tool and is still not providing notices. I think the association is going to address some of those concerns. I have a lot of concerns about this. One of my concerns is that input was not received from the public until after these were sent to the state register. The agency needs to do a redo and obtain input from families, providers, advocacy organizations, and the local boards throughout that process, instead of waiting and then giving people who have a really important interest in this just 30 days to respond. I just feel like all of those directives and standards, those need to be promulgated as regulations so that there's uniformity across the state, and so that there begins to be some compliance with the ADA in terms of providing services in the least restrictive setting. Thank you.
Thank you, Ms. Harrison. I appreciate you stopping on time. All right. The next individual who has requested the opportunity to address us is Ms. Nancy Banov. I believe she might be with SCAA, but we'll try to get some clarification from that when we contact her.
Hello.
Ms. Banov,
Yes.
this is Gary Lamel with the DDSN Commission.
Yes. Hey, Gary. Hi. Nice to hear from you.
Yes, ma'am. So if you if you weren't able to hear us, there was some question about that. We're in the public comment section
Yes.
regarding the regulations that were submitted.
Yes.
We have asked for people to limit their comments to 5 minutes, so we'll be keeping a timer on that. And if you
Sure.
need to supplement after that, you're welcome to do so in writing. I would ask you before you begin, if you could identify what organization are you with?
South Carolina Associates of Advocates.
Okay, thank you. There was some confusion in the email we got about that, so thank you for clarifying that. So I'll now recognize you for 5 minutes. Thank you, ma'am.
Sure. All right, here we go. The South Carolina Association of Advocates was established in 2019 to provide advocacy, information, and education to DDSN clients and their families. SCAA is pleased that DDSN is moving in the direction of promulgating regulations. However, our organization is concerned about DDSN's failure to obtain public input before determining what matters would be addressed in these proposed regulations prior to publication in the state register. SCAA recommends that DDSN hold public meetings to receive additional input before these regulations and any others are approved and resubmitted, taking into consideration that many families do not have computer skills. SCDDSN should receive input from DSN boards and advocacy groups, as well as from clients and families, informed through notices provided by case managers and easy-to-read and understand language. A thorough review should be made with greater public input during this process to promulgate regulations to replace the agency's many directives and standards, which can and have been changed without legislative authorization. DDSN should promulgate regulations to align its practices with state and federal law. For example, the Medicaid Act clearly mandates that all providers must be allowed to bill the state Medicaid agency directly. Regulations should be promulgated to bring the agency into compliance with the Medicaid Act and the ADA, addressing such issues as conflict-free case management, choice of settings, how room and board is calculated, and to require that quarterly accountings be provided for expenditures of personal funds of residential clients. DDSN needs regulations to clarify the rights and responsibilities of family members, clearly stating that a family's financial resources may not be considered in allocating services to adult clients to services. Regulations are needed to bring DDSN and providers in compliance with the Adult Health Care Consent Act, so that providers understand the requirement that consent must be obtained from the person with priority under that act when the client is unable to consent. Regulations are needed to establish standards used to allocate services, and DDSN should adopt in regulation standardized assessment tools so that clients and their families know what criteria is used to approve or deny requests for services. Regulations need to include a form case managers submit to DDSN to establish the date when requests for services are transmitted to DDSN. The regulation should provide that when requests are not acted upon within 90 days, the case manager must send a written notice to the participant explaining the delay and exactly what additional information needs to be provided to process the request. These regulations need to require clear written explanations for DDSN's reasons for denying or reducing service hours. SCAA is concerned with the proposed adoption of DSM eligibility criteria that may be changed by a non-governmental entity, the American Psychiatric Association. Future changes in DSM definitions may result in DDSN clients who have been depending upon services for years suddenly becoming disqualified. SCAA objects to the continued illegal use of a bright line IQ score, taking into consideration that determining whether a person has ID not only affects the provision of services, but also critical judicial decisions, including whether a person with ID may be put to death. The proposed definition of ID is not consistent with the current DSM definition or decisions of the U.S. Supreme Court. Regulations should address the standard measure of error and other factors that must be considered in diagnosing ID. Input should be received from providers of psychological services and behavior support providers who serve DDSN clients in correcting these errors and omissions. SCAA recommends that regulations be promulgated to clearly define the roles and responsibilities of DDSN and its providers in investigating and responding to reports of abuse, neglect, and exploitation. After PNA, now Disability Rights, issued its Unequal Justice Report in 2005, DDSN transferred licensing of group homes to DHEC without commission approval. DDSN returned to licensing these homes. Continue an abuse and neglect document. Okay, that's it.
That's our 5 minutes.
Sentence.
Yeah, I appreciate that. If you wish to submit your statement, your written statement to us, you can do that and we'll look at it, okay? So that anything, any material that we
I'm
get.
sorry, it's kind of an echo with your voice.
Sorry.
What you said?
You may submit the remainder of your statement or your entire statement in writing to us for us to consider.
Sure, I can do that. I can submit that in writing. Okay, we'll do that.
Thank you very much, ma'am.
Who does that get sent to? Where does that get sent to?
If you want to send that to Ms. McLeod.
Ms. McLeod?
Yes. She'll get in contact with you and give you an email address. How about that?
Address, email? Sure, I can email that to her, sure. Thank you so much for allowing me to speak. Thank you.
Yes, ma'am. Thank you.
You're welcome. Bye-bye.
Okay. And then the last individual who is requesting that to present to us today is Rebecca Spanagel. I hope I am pronouncing her name correctly. If not, I will beg her forgiveness. And she's with Disability Rights.
Mr. Chairman, it would be very helpful if those who are calling in, if they could submit their stuff in writing to us, because that's a lot to take in.
Yeah.
And we aren't really sure.
This is Rebecca.
Rebecca, this is Gary Lamel with the DDSN Commission. How are you doing today?
I'm doing well. How about you?
Just fine, thank you. We have begun the portion for public comment, and we do appreciate it. It looks like Disability Rights has submitted a written response as well. We appreciate you doing that, but we will recognize you to provide public comment at this time. And we are limiting that to 5 minutes. So once we begin, we will have you on a timer, and we just ask that you respect that timer.
Yes, sir. Thank you, Commissioner.
Yes, sir. So we'll recognize you at this time.
Thank you. Good afternoon, Commissioners. As stated, my name is Rebecca Spanagel, and I'm an attorney with Disability Rights South Carolina. We appreciate the opportunity to give public input on the proposed regulations this afternoon. As you know, Disability Rights South Carolina is the protection and advocacy system for the state of South Carolina. We protect and advance the legal, civil, and human rights of people with disabilities in South Carolina. As stated in our letter dated March 29, 2021, Disability Rights South Carolina remains concerned that DDSN has not taken the opportunity to fully incorporate its directives and standards into these regulations. We do appreciate the efforts that DDSN has made to submit these proposed regulations. However, we firmly believe that incorporating additional information and details from the directives to the regulations will ensure adequate notice of policies to the public, better enable individuals with disabilities to navigate systems, and better ensure best outcomes for people with disabilities. Now is the time for DDSN to fully incorporate its directives and standards into the regulations. Having said that, I want to take my remaining time to briefly emphasize 2 additional points we outlined in our letter. First, we are concerned that the articles on eligibility and appeals seem to only regulate processes relating to individuals receiving or seeking eligibility for solely state-funded services. Our concern with this limitation is twofold. First, by limiting these articles, DDSN has only provided information about these areas to a very small subset of individuals that it serves. For example, as currently proposed, these 2 articles do not cover eligibility and appeals processes for waiver participants. This is in opposition to DDSN's statement of the need and reasonableness of this regulation as published in the State Register, which acknowledged that the proposed regulations are needed to ensure that all applicants for services are aware of the process and their rights. As an example of how this affects waiver participants particularly, information about DDSN's reconsideration process is not included, but is sorely needed as it is required by the Department of Health and Human Services for waiver participants to engage in this process prior to being able to appeal a decision regarding eligibility or services to a Medicaid fair hearing. The language that is needed to add to this regulation regarding the reconsideration process is readily available to DDSN, as just today the Commission approved Directive 535-11DD that includes vital information about the reconsideration process. However, even if DDSN proceeds with limiting the regulation's applicability, our second concern is that the text of the regulation does not make this limitation sufficiently clear. For example, in regulation on appeal, DDSN utilizes the term DDSN services throughout, and it's also utilized in the article on eligibility without defining it or providing that it only covers state-funded services, which could easily confuse the public. Therefore, while I understand that the Commission is not responding to comments or questions today from speakers, we would appreciate clarification as to DDSN's purpose in limiting the applicability of the regulations to the extent that it is willing to do so. In addition, Disability Rights South Carolina highly recommends incorporating waiver policies and procedures into these regulations to better serve the need for all applicants to be aware of the process and their rights. In addition, as raised by the previous speakers, we also have concerns surrounding the eligibility criteria for individuals with intellectual disabilities. As we noted in our letter, we are concerned that DDSN included a cutoff score of 70 for IQ testing in the regulation. This is in opposition to DDSN's adoption of the DSM-5 criteria and the DSM-specific guidance and warning regarding over-reliance on IQ testing scores. The authors of DSM-5 recognize that individuals with higher IQs could present with other deficits in intellectual and adaptive functioning, and thereby caution that clinical judgment is required when interpreting IQ testing. Additionally, DDSN does not recognize a standard error of measurement in this regulation, which is generally a range of plus or minus 5 points. In essence, not only by failing to acknowledge a standard error of measurement, but also requiring a specific score which is outside of DSM-5's requirements, this essentially creates a situation where an individual who has been justifiably diagnosed with intellectual disability by a qualified clinician could call DDSN for help and for access to services, but ultimately be denied. Therefore, to briefly conclude, we would encourage DDSN to seriously consider our verbal comments today and also the written comments contained in the letter that I've referenced throughout regarding these areas and make relevant changes to the regulations prior to promulgation. Thank you.
Thank you very much, ma'am. We appreciate your respecting the time limit.
All right, thank you.
Thank you very much. Okay, there being no further requests for public comment, I don't think there's any formal action we have to take today other than to adjourn. So the regulation is submitted, we take public comment, and then ultimately they get adopted by the legislature, correct?
Well, what we will do is we'll take all the public comment into consideration, do new drafts, present them to the legislative committee, have the legislative committee approve them, have the full commission reapprove them, and then submit them to the legislature.
Thank you for that clarification. Any other questions? Procedurally?
Accepted. So you haven't, so you'll get back to the legislative committee about which ones you would consider, obviously, some of those you're not gonna consider getting in, so once you are, you're gonna get back to them on David on the next.
Well, I will say the disability rights letter is very well done, and it clearly outlines what their issues are. I had some trouble following Patricia. I was trying to find it in all the various documents we've got. I think if we could get more people to do a letter like Disability Rights did, so that we can, as a legislative committee,
written documents would be good.
I think that would help. If we could call them and ask them to put their comments in writing, that way we have them when we sit down.
I think they were all reading it too, so.
I think they were. So
yeah.
if we could get that, then go back and check our stuff and get theirs to make sure everything's included, I think that'd be great.
And specifically, as we talked about, if you can contact Ms. Banoff with your email address so that she can email that to you, and then you just distribute that out to us. That
We're not under any big time constraints. Nothing that's precedence at this point. Time-wise, because of where we are in the session, so we got plenty of time to work on talking about it.
Wasn't there a deadline for us to respond on these regulations that we were found
by this, give me the background. This, wasn't it the,
It was the amount of time that we gave notice for this public comment. There was a question about whether we could do it when we didn't have a quorum. Remember, we were going to try to have the public comment before we had new appointees, so we tried to set it, and they came and we just said, no, we'll withdraw that, and basically redid the process to come where we are right now. So I think our timeline, we're good now. The prior timeline was disrupted by the lack of a quorum.
Okay.
gotcha. Okay.
I think that's what you're thinking.
Yeah, I was just trying to.
Right, that's when somebody asked the Supreme Court to intervene and stop us from holding it, and we just said, fine, if we're gonna fight about it, we're not gonna do it. We just withdrew.
All right, and someone, there was another question that, Gary and I wasn't really familiar. They said that we had not put it out to everyone to give them time to comment on it. What did they mean by that?
More than 30 days, but.
What, the law says 30 days, is that how that works, or
Well,
what?
we had given very sufficient notice in the
Okay.
state register.
Okay,
And that's the only place that we're legally required to publish those. We
okay,
did, and, we sent them out and put them on our website.
Yeah.
Okay.
So everyone did have sufficient time to
to respond.
respond.
We elicited responses
Okay,
well in advance, in my opinion.
I wasn't sure. I mean, I
Yeah.
just didn't know. I wanted to clarify that. Very good.
Okay,
Most of those comments they made related, I thought, to, I mean, we have policies already, it's just, they just wanted to put it in regulation, but.
Correct.
Put it in regulation, it makes it much more difficult to update it or anything else.
correct.
So we have to be
There,
very careful what we put in regulation, what we already have in policy.
right, that has been sort of the ongoing tension that we've talked about ad nauseum, quite frankly, about what we want as policy and what we want as regulation.
Okay.
Exactly.
Policy gives us much more flexibility.
Yes.
But it's uncertain sometimes, and sometimes possibly a little more contradictory, and possibly outside scope of the code. So it does raise all kinds of interesting legal questions.
Okay.
It does. Okay. All right. That being said, is there anything else we have to do from an administrative standpoint with regard to the public hearing?
Not that I-
Okay, then would entertain a motion to adjourn the public hearing.
So moved. Second.
All in favor, please indicate by saying aye.
Aye.
Any opposed? We stand adjourned.